Okay, class, this is going to be your test only. On your 160 number 1, you have Oak Road, Dodge. Make sure you access the speed building before, okay? This is test number 1, 160 lit for 5 minutes. The plaintiff contends that because of the negligence of the defendant, she was struck and injured by another motorist. It is claimed that the injury that she sustained is a direct result of the defendant's negligence while operating a motor vehicle. The plaintiff must prove her claim by demonstrating the negligence, which places the burden of proof upon the plaintiff. Plaintiff contends that she was struck while driving on Oak Road by another vehicle driven by the defendant. Plaintiff was proceeding westbound on Oak Road during the daylight hours near the time of 2 p.m. in the afternoon. The accident between the plaintiff's vehicle and the defendant's vehicle occurred at approximately 2:01 on July 12 of this year. Plaintiff contends that the defendant's vehicle swerved over the center line and struck her vehicle, the Dodge. At the time of the accident, the plaintiff's vehicle was traveling westbound on Oak Road and the defendant's vehicle was traveling eastbound on Oak Road. Both drivers agree that the visibility in both directions on Oak Road was good. Oak Road is a straight road at the site of the accident. There are no curves or obstructions at the scene of the accident. There are no curbs or trees that would block the visibility at the scene of the accident. The nearest intersection to the scene of the accident is approximately 1/4 of a mile east of the accident site. Plaintiff contends that she was traveling at approximately 40 miles per hour. The speed limit on Oak Road is 45 miles per hour. Plaintiff is unaware and cannot speculate on the speed of the defendant's vehicle. Plaintiff contends that the plaintiff's vehicle crossed the center line coming from the opposite direction and struck her vehicle in the left front bumper. As you can see, a disagreement in the facts arises because of the circumstances of the accident. Was there negligence on the part of the defendant that contributed to plaintiff's injuries? Was there contributory negligence on the part of the plaintiff which caused the defendant's vehicle to strike her vehicle while traveling on Oak Road? Both parties agree that the plaintiff sustained some injuries in the accident, but both parties do not agree on the extent of the injuries received by the plaintiff in the accident. It is important to examine all of the steps in this case to determine what really happened and come to a fair and just conclusion for both parties. Let's define negligence. Negligence is a failure to adhere to a preconceived standard of care. In society, certain standards and rules of conduct are what we live by. These standards of conduct are necessary in order for individuals to live together in relative peace and harmony. Each person must live his life in such a way so as to not interfere in any way with the lives of another. Negligence exists when one person does not follow the necessary degree of care that the rules of society expect. Negligence in law is defined as the failure to use a reasonable amount of care when such failure results in injury or damage to another. Plaintiff contends that the driver of the other vehicle, the Ford, was negligent. Plaintiff contends that the defendant's vehicle crossed the center line and struck her vehicle on Oak Road, approximately 1/4 of a mile from the nearest intersection, while plaintiff's vehicle was proceeding westbound and defendant's vehicle was proceeding eastbound. Plaintiff contends that all of the reported injuries were sustained by her in this accident. There were no pre-existing injuries at the time of the accident. A close review of all of the medical reports in this case is important to determine when and where all of the injuries received by the plaintiff were sustained. Let's define contributory negligence. The definitions of negligence and contributory negligence are very close. Before you can identify contributory negligence, you must find an act on the part of the plaintiff which contributed in some way to the negligence of the defendant. If you can find that any act on the part of the plaintiff in any way contributed to the accident, the defendant cannot be held accountable for the accident on Oak Road. The operator of a motor vehicle must exhibit certain standards of care. These standards of care must be adhered to in order to qualify as a driver on the public streets in this state. As the operator of a motor vehicle, the driver must exercise consistent control foreseeing imminent danger, and other hazards that are presented while driving on the road. A driver of a motor vehicle has the duty of driving a reasonable and safe speed depending on the road conditions, regardless of the speed limit. A driver of a motor, and then we have your second test, proper names, XYZ Company, and number 35. This will be your test number 2 for 5 minutes, 160 left. The plaintiff contends that while working for the XYZ Company, he sustained back and foot injuries. Plaintiff contends that the management was aware of the hazard and the conditions that existed on the job and did nothing about them during the time of plaintiff's employment with the XYZ Company, which lasted for a period of less than 1 year. Plaintiff's employment with the XYZ Company commenced in January of last year. Plaintiff was hired to stock the freezer compartments for the XYZ Company. There is evidence of the following facts. The freezer compartments of the XYZ Company were kept at below normal freezing conditions necessary for the storage of frozen foods. The freezer compartments had excess layers of frost and ice caused by a faulty refrigeration system. The freezer compartments contained discarded packaging materials that remained stuck to the sides and walls of the freezer compartments, causing a buildup or residue on the freezer walls. The area around this entry to the freezer compartments was not kept clean and free of debris for any easy access. Plaintiff further contends that protective clothing for the hands and face was not provided by the management of the XYZ Company. Employees were expected to work in freezing conditions, loading and unloading food supplies without the proper uniforms and gloves with which to work. Plaintiff contends that proper footwear was not made available to the employees of the XYZ Company in order to protect the toes and feet from frostbite. At the time of plaintiff's accident, he was working the night shift, which runs from 10 p.m. to 5 a.m. 3 other employees were also on duty loading and unloading food supplies from the freezer compartments of the XYZ Company. Plaintiff contends that during the evening shift on October 22, he slipped and fell inside freezer compartment number 35. At the time of the accident, his other 3 co-workers were on a break. Plaintiff contends that the door of the freezer compartment became wedged against his right foot. As he attempted to free his right foot, he slipped and fell, injuring his back and right foot. Plaintiff contends that he was unable to move after he fell in the freezer compartment. He was discovered 10 minutes after his fall by his co-workers, who immediately sought medical assistance. Plaintiff contends he also sustained minor frostbite to his exposed arms and legs and face. Plaintiff contends that because of these injuries, he is unable to seek employment. Plaintiff contends that the management of the XYZ Company was careless and negligent. There was no supervision on the job during the night shift. Plaintiff contends that the management of the XYZ Company was aware of the dangerous conditions that existed in the freezer compartments. Plaintiff contends that the management of the XYZ Company did nothing to improve the working conditions for its employees. Plaintiff contends that at no time was protective gear ever offered for employee use. The complaint charges negligence and lack of reasonable care on the part of the defendant, the XYZ Company. Plaintiff's brief argues that defendant lacked reasonable care in the daily operation of loading and unloading the freezer compartments of the XYZ Company. Defendant failed to exercise reasonable care to protect its employees from possible frostbite and other injuries that may be sustained during the normal operation of the business. Defendant is chargeable with the knowledge that the employees were never offered protective gear, nor was it suggested that the employees of the XYZ Company wear protective clothing and footwear to prevent frostbite and other related injuries. Defendant is chargeable with not providing adequate supervision during the night shift, which could have prevented this accident from occurring. Defendant is chargeable with the knowledge that the spring-loaded mechanism on the door of freezer compartment number 35 had not been maintained nor repaired, although repair orders show that it was reported to management on 2 different occasions that the door to the freezer compartment number 35 did not open or close properly. Defendant's replies to these allegations are insufficient. Defendant's failure to provide adequate footwear and clothing for the employees on the job is obvious. Defendant lacked the necessary degree of reasonable care to ensure that employees of the XYZ company were protected from hazardous conditions that existed at the job site. Defendant failed to supply adequate job supervision for employees working the night shift. Defendant failed to respond to warnings, both oral and written, from the employees that the spring mechanism on the door to freezer compartment number 35 was not operating properly. This accident is a direct result of the faulty spring. Okay, and that concludes your test, you all. Good luck. Type them up, see how you're doing. Hopefully you got one, okay? Have a great day, you all.